May I please, Your Lordship? My lord, I may be permitted to move one IM, my lord, unlisted for correction of your lordship's order, my
Tomorrow,
tomorrow.
I beg to mention lordship for listing one requisition for motion lordship.
when was it filed?
It was filed on 12.
12th. Wednesday?
Wednesday.
Lordship, I have prayer with respect to item 12, Lordship.
Item 12.
Not pressing this matter, Lordship. Having been influx of loss.
Item 12. Mr. N. Patel, Learned Counsel, appearing for the petitioner in item 12, submits on instructions that this petitioner does not wish to press the petition any further. Accordingly, same stands dismissed as not pressed. Interim orders, if any, stand vacated, pending I's are also dismissed.
May I please, Your Lordship? Lordship, I'm praying for listing of some writ petitions, Lordship, in the motion, Lordship. I have filed it on Friday, Lordship.
Friday, Wednesday.
Wednesday.
May I pray for listing of a motion tomorrow? It was listed earlier, but in the wrong bench, my lord.
Tomorrow.
Tomorrow, oblige.
My lord, I get to mention for listing, my lord, motion matter, my lord. A similar matter is, my lord, listed before this court, my lord, on tomorrow, my lord. So, my lord, can it?
What is the matter about?
My lord, regarding constable, my lord, selection.
It's listed on every day. Today also there is some matters listed. Day after tomorrow?
Oblige.
Prayer, my lord, prayer for listing of a motion matter, my lord, day after tomorrow, Wednesday.
Yeah.
Deeply obliged.
Lordship, I have a similar prayer for motion on 18th, my lord, Thursday.
Prayer for a motion matter, Lordship, first motion matter, they are
Let it be on 18th.
May I please, Your Lordship, I pray for listing of 3 petitions on Wednesday, Lordship.
Motion,
Yes, Lordship.
not on 18th.
So can it be on Wednesday?
Thursday. When is up?
Always.
Similar prayer also.
Motion.
Motion.
May I please, your lordship?
What is the subject matter? Bench 3 matter.
Wednesday matter also.
Day after tomorrow.
May I
Blah, blah,
please, your lordship? Lordship, I beg to mention for listing of a fresh matter, repetition matter. It has
Fresh
been,
matter, when was it filed?
on 9th December.
9 December, not listed.
No, lordship,
Was it not listed ever?
no lordship.
Why will it not be listed? Did you?
Lordship, there was an objection.
The objections cleared now.
Lordship, today we will hear. the
No, you clear it, then you make a mention tomorrow.
Lordship,
Yes.
May I please, Lordship? And one compassionate matter, Lordship, the issue was relating to minimum 3 years balance period. That issue has already been decided by the Honorable Division Bench, Lordship. May I pray, Lordship, may be listed on Wednesday, Lordship. Only consequential order will require.
Not a motion,
No, admission matter.
admission in January. This is only motion miscellaneous matters, na? So admission matters, you will have it in January, 9th of January.
My dear lordship, I am prepared for supplementary list item number 39. Customer for after vacation.
39.
Yes.
All right. Item 39. Why pass over?
My senior is not well
We are dismissing your matter. You appear.
after vacation. My lord.
39 to be listed again on 7th of January 2026 on the request made by counsel for the petitioner.
May
it please your
lordship? Lordship, I beg to mention item number 18 of the daily list.
18.
Yes, your lordship. The conducting counsel, Mr. H.K. Das, is out of station, lordship. So it may be kindly taken up after vacation.
18 to be listed after vacation on on 19th January
Deeply obliged,
2026 on a request made by the council for information.
May I please your lordship? Lordship, item number 23. Matter has become infrastructure. Lordship.
You are for
Petitioner.
item 23 on a request on a submission made by your name,
SP Das, lordship.
SP Das. Counsel for the petitioner submits on instructions that the writ petitioner does not wish to pursue the writ petition any further. Accordingly, the same stands dismissed as not pressed. Interim orders, if any, stands vacated. IA number so and so, and other pending IAs are also dismissed. The IA has it below, I think. Yes.
Please, your lordship. Lordship, prayer for listing of a matter in the admissions column, Your Honor.
Admission in January, 19 January.
Can it be taken before vacation, my lord, matter pertains to non-payment of retirement benefits. She has
We
not
can
been
give you
given
an,
retirement
we can give you an early date in January,
before Bihu vacation.
7th of January.
May I please, your lordship. Lordship, I'm praying for listing of one writ petition, motion matter, lordship, for Wednesday, lordship.
Wednesday on.
Obliged, lordship.
When was it filed?
Lordship, it was listed on 22nd of October, lordship. May I please, your lordship. I beg to mention item number 14.
1-4.
Yes, lordship.
Oh.
I was instructed to withdraw this matter as the petitioner not one.
MS Somali.
Yes,
Somala. Somila.
Yes, lordship.
Learned counsel appearing for the petitioner on instruction submits that the writ petitioner does not wish to press the petition any further. Accordingly, the same stand dismissed as not pressed. And interim orders, if any, stand vacated. Pending ayes are also dismissed.
Obliged.
May it please, your lordship. I beg to mention item number 30 of today's list.
30.
30. We are appearing for the petitioners here, and I have already taken the consent of the learned senior counsel. So, your lordship, let the matter be fixed on 6-1.
Mr. S. Dotto, counsel for the petitioner, submits that the matter be listed in the month of January. He submits the consent has also been obtained from the writ petitioner.
Of the respondent,
Of the
applicants
respondents,
here.
the respondents, that the matter be listed on 8th of January.
Lordship, in I, there is an interim order.
Interim order will continue till the next date.
Obliged.
Interim order passed. Yes.
Chief, I beg to mention item 42 of today's supplementary list.
Hmm.
Lordship, in this matter, inadvertently, some documents have not been annexed. I pray that it may be taken up day after tomorrow. In the meantime, I'll file an additional affidavit bringing on record those documents.
Item 42 to be listed on Thursday
Obliged, lordship.
at the request made by Mr. MP. Yes.
Please, your lordship. Lordship, I just came to know for listing of a fresh matter, the objection has been cleared, lordship.
All right. Wednesday, subject to clearance of objection.
Lordship, on 17th.
Hmm?
So, on 17th.
17th, yes, Wednesday. 17th is Wednesday.
Lordship, obliged.
Mayor, should I pray for listing a representative motion, lordship? It was filed on 12th of December. Obliged.
None appears for the petitioner on call. Mr. T.C. Sutia appears for the government. Mr. J. Hendick for the revenue department. None had appeared for the writ petitioner when the matter was called on 24/9/25 and 8/12/25. Accordingly, writ petitions stand dismissed as for non-prosecution. Interim orders, if any, stand vacated. Pending ayes are also dismissed.
The contempt petition against the order dated, my lord, 29/7/2025, my lord.
I heard the council issue notice returnable 4 weeks. Steps on the respondents by registered post within 1 week from today. It's after returnable.
Marks of
Yes.
Lordship is against the deliberate and willful non-compliance of the order of this honorable court passed on
Where is
16.
that order?
Lordship, the operative portion is at page 65, madam,
65.
paragraph 46. Was passed on 16/9/2025, madam. And thereafter, we have communicated the order by annexure 2, madam, on 22nd of.
Council for parties issue notice. Returnable and so on. That I got low idea, but the challenging willfulness, deliberate violation of the order. Steps on the respondent by registered post within 1 week. Be listed after returnable dates.
Debris obliged.
The respondent was supposed to take the instruction regarding disposal of the appeal. Imposing penalty.
Yes, respondent who's there?
Sorry.
My lord, we have not received any ballot instructions. The lordship may dispose of ballot directing the appellate authority to ballot complete the appeal, my lord.
Why can you not get, where is the appellate authority?
Appellate authority, good luck.
There is 85.
Huh? Where is the appellate authority?
Appellate authority. Okay. Governor.
Hmm.
Governor, my
Who
lord.
is the appellate authority?
Governor of Assam, through, we have sent through Commissioner and Secretary. Government
Then
of
we'll
Assam.
have to issue notice, you have to get your instructions here. Or we keep it after vacation.
Better issue notice, my lord. In the meantime, we will send copy.
No, but if the appeal is already disposed of,
Oh, yes, yes.
then then.
No
makes
need to
sense
issue
notice.
After vacation, my lord.
We'll have it on 7th January. Mr. S.K. Goswami for the
7th January,
Here, learned counsel.
My pension has been permanently withheld. After retirement from service, 12 years back.
We are giving you, we can give you on 5th also.
9th of January, my lord.
No, 9th is too late. 7th. 7th January.
7th
Counsel for the petition.
January. Oh, good, sir.
By the earlier order dated 26/11/2025, the respondents were permitted to obtain instruction with regard to the status of the appeal filed by the petitioner before the appellate court. Today, when the matter is called up, the government council submits that instructions sought for have not been received. Accordingly, this court considers it appropriate to defer the matter and have it listed on 7th of January, permitting further time to the respondents to complete their instructions. Extra copies of the writ petition, if not furnished already,
Already punished.
should be furnished within a week's time.
And
Mr.
respondent
Gaurav
five
for
units.
Respondent 5.
May I submit one thing?
RK Talukdar, Your Lordship.
They have
On
withheld,
behalf of RK.
they have withheld the pension permanently. My gratuity also not paid, Lordship. Gratuity is not.
The pendency of the writ petition will not restrain the respondents to process and release the gratuity payable to the writ petition.
Obliged.
Five.
Review medical board records required lordship in this case hemoglobin due to hemoglobin less than 12 ml.
Where is that? Where is that order?
Page 49.
Where is the RME? RME order?
RMA 49.
49.
49.
Anemia.
Anemia.
And where is on which date was it conducted?
It was 27/11.
27/11.
And page 55, your lordship, it was on 13/11/2000. 3/11. It was 12.3.
No, it is on 30/11.
Yes. Next page 3/11 of
14.1.
14.1.
This is 51 is conducted by whom?
51 by, it was
By you
active
only?
care clinic. Active care clinic.
By the petitioner only.
Yes. Only, yes.
So then it was below on 3/11.
Yes, sir. It was 3/11.
It was
But
below.
12.3 here in. And the minimum range is given 13 to 17. As per the guideline, your lordship, the minimum your lordship 12 it will be. 12 to 16 your lordship.
Petitioner is aggrieved by his rejection during the process of selection and appointment for the post of Constable GD in CFEF. Stop petitioner was rejected by the medical board for being found. Was rejected on medical grounds within bracket hemoglobin below required parameters. So, according to the petitioner, subsequent tests made before the Apollo clinic revealed that his hemoglobin was within normal range. So, let the respondents complete their instructions and apprise the court on the next date fixed, list on 9th January 26.
Get an extra copy. I didn't see.
Herein hypertension and poor dental point.
Heard counsel for parties issue notice returnable for which Mr. S.S. Roy, S. Burwa, Ms. S. Burwa, appears on behalf of all the respondents, therefore notices are waived, extra copies will be furnished within a period of 1 week from today.
Same date.
Not same date, we are issuing notice here. Because you'll require,
All right.
their affidavit will be required.
Obliged.
Matter pertains to my lot, non-payment of retirement benefit as well as family pension. At this station, notice may be issued. The petitioner's husband, my lot, is serving as a master worker, regularized in the year 2005, my lot.
Where is the order of regularization?
Regulation order, my lot, unlisted annexure 1, my lot, page 17, 13 September 2005. But he has not paid the malat regular scale of due to malat anomalies in the order malat, date of birth, date of retirement. Subsequently, malat process for correction was taken malat, but till that malat he has not paid the regular scale of pay, and in the meantime malat he retired and died malat.
Heard counsel for parties issue notice returnable for which Mr. Aldgore appears on behalf of respondent 1,
1, 5,
5, 6, 7.
7.
Mr.
Lordship, I am appearing for 2 and 8.
Nayak appears for respondent 2,
2 and 8.
2 and 8. Mr. Boro for number 4
My friend is-
and MSS Borua for number 3. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from today.
Obliged.
8.
ONGC, we can't serve the call because there is no legal standing counsel of ONGC.
No?
Because there is no standing counsel of ONGC. Because when a notice goes to them, then they engage.
What are you challenging here?
No, we are saying, my lord, our case is not been considered for promotion from A2 to A3 level. Now they say, my lord, there was a penalty which was inflicted on us, penalty. That penalty period is over. I was initially A1 level, that which calls a junior assistant regiment.
What is the penalty
Really?
imposed?
Penalty imposed is a reduction of pay for a period of 9 months or 10 months. And thereafter that was removed. And that removed, I was again promoted from A1 to A2 level. Now when the promotion is due for A3 level, now they bring back that original penalty which was imposed. And they said, no, we can't do it. You have to remain for 5 years. Now we said that we have replied.
Where is that penalty
Yes,
order?
I'll show that penalty order first. See, please, page 40, my lord. Page 40. This was of 9/10/2019, my lord. See this. Para 3. Whereas taking into consideration the charges level against the employee and the reply submitted, undersigned has come to the conclusion that the ends of justice would be met, imposing penalty reduction of 1 stage lower in the scale of pay for a period from 1/10/2019 to 30/9/2020. During the period of reduction, so and so will not earn increment on expiry of such period. the reduction will not have effect of postponing future increment of pay. Now, please see, place 44, kindly see my lord, page 44. Once it was over, that period was over, I was again promoted. See, at page 44. 44 is 24/12/2021. What you got it? Promotion order, and kindly see at page 48. At serial number 99. This is serial number 99. I was A1, I was promoted to A2. Now, they came with an OM, kindly see at page 52. That is my lord, Central Public Sector Enterprise. See the OM at page
So
52.
when is the promotion considered?
1/1/2025.
25.
25. Then
Your penalty is for this period only.
only. Thereafter, I was promoted. So they cannot, now you see what they are saying at page impugn is at page,
Will issue notice at this.
yes, yes.
We'll have to serve copies on these.
No, sure.
Whoever.
Of course, my lord. Page 65, kindly see, there's impugned. Page 65, because your lordship has to. See, what is the impugned? 65. As per SAP record, insurance penalty order dated 9/10/2019, menial penalty reduction lower stage lower in the scale of pay for a period has been imposed. Accordingly, as per clause 15, para 4.2, resilient claim was not granted. Hence, you have not been promoted with effect from 1/1/2025. And if you see at page 68, kindly see what they are referring. At page 68 is the conduct discipline appeal rule. At 150, see the relevant portion at 150. 150. 150, they are referring of 2024 office memorandum. See 15, my lord. And para OM dated 29/7 has notified the council revised vigilance policy. See para 4.2. In case of imposition of major penalty, vigilance clearance will not normally granted for a period of 5 years. After the currency of the punishment during the period, performance of officers should be closely watched. So now you cannot bring that 2019. By the time I have been promoted, what remains that you have to promote now from A2, A3, unless there is some other penalty leveled against me. There is none. And kindly see, now at page 155, office memorandum, their office memorandum. See, my lord, what they have done it, they have modified the recruitment promotion policy and they have inserted this clause, 4.5. Now see at clause 5 at 155. See 5. The provision of new clause as mentioned at para 2. Para 2 is 13 is inserted, so a penalty has been imposed. Provision of new clause as mentioned in para 2 shall be applicable for all promotion to be considered after issuance of this OM. Now this OM has been issued on 28/2025. So prospective, they cannot. This is my case, man.
Heard Mr. D. Das, Learned Senior Counsel, assisted by Mr. A. Mohammed, appearing for the writ petitioner. Petitioner is agreed that he is, in spite of fulfilling all eligible criteria for being promoted to the next higher post of what grade?
A3 level. A3 level.
In the ONGC, petitioner has been overlooked and his claim for promotion has not been considered. So the petitioner incurred a penalty pursuant to proceedings initiated against the petitioner for reduction of pay, which culminated in a penalty for reduction to lower stage in the scale of pay for the period 1/10/2019 to 30/09/2020, italics. So the petitioner, the counsel for the petitioner, senior counsel for the petitioner submits that the period for which the penalty was imposed has long expired. And now when the petitioner's case has been ought to have been considered for promotion to the next higher post, the same is not being considered by placing reference to an OM dated 2008-2025. Stop, it is submitted that this petitioner's claim for promotion is with effect from 1/1/25.
1/1/25.
And the OM came to be issued on 2008-2025. Therefore, the provisions of his OM could not have been applied to the case of the petitioner, whose claim is based with effect from 1/1/2025. Stop. However, the respondents having declined to accept the claims of the writ petitioner, the present writ petition has been filed. Taking into consideration the submissions made, issued notice returnable 4 weeks. Steps on the respondents by registered post within 1 week from today. Matter be listed again.
Only one request, my lord. Can I take a dusty service on 3, 5 and 6? So I don't want a third party, right? Again, someone will be promoted again.
2025,
Yes.
28th, list on 28th of January.
Yes.
The petitioners are also permitted to take service by way of dusting
On for 3, 5 and 6.
on 3, 5 and 6.
Rest by register speed post, my
No,
lord.
you take registered post on
Speed
all.
post. Yes.
Speed post on all
Yes.
and dusty on this.
Yes, correct. Correct. Your lordship, your lordship can say my present designation deputy technician drilling A2.
The road leading petitioner is presently serving as
Deputy technician drilling
Deputy
A2,
deputy technician
bracket drilling
bracket
A2,
A2,
which is now next will be A3.
and is seeking his promotion in the next level of A3.
Deeply obliged.
May it please your lordship. Lordship, all the petitioners are retired employees of the Guwahati Municipal Corporation, my lord. The grievance is that from 2024, my lord, they are not receiving their pensions regularly. And as your lordship knows, pension is the only source of livelihood for them, my lord. And in order to, so to your lordship may kindly see Annexure 5, page 83, my lord. That is record of disbursement. So as per this record, my lord, there is always a delay of 30 to 154 days. That is around 2 to 6 months, my lord. So that's, and we have submitted various representations also, my lord.
We
and
issue notice at this stage.
Lordship.
Interim praise.
What interim?
Lordship, from July
we are in fact same-
2025, they are not receiving their, so whatever.
Let
things they are
notice go at
entitled-
this stage, my lord.
So at
I'll
least
get it.
outstanding pension may be released, madam.
No, let them obtain the instruction first.
But if the direction is given, my lord, then they will speed up the matter.
Your prayer is to
Main prayer in the
directing them
first
to
listing.
release the pensionary and outstanding dues. Page number 20,
Yes, madam.
serial number 1,
Yes, madam.
outstanding pensionary dues and arrears.
Yes, madam.
That's your prayer.
But in the interim.
Now, if we grant an interim prayer, what will be left to be decided finally?
Only then just
We'll
one.
issue a notice on your interim
Only
prayer.
just one observation, the pendency shall not be a bar for them to release.
Heard counsel for parties, we shall notice returnable for weeks. Mr. S. Bora. Standing counsel, Department of Housing and Urban Affairs.
I appear for
accepts
phone number
Notice on behalf of respondent number 1,
1, 2, 5 and 6.
5 and 6. Mr. A. Chakraborty for respondent number 4.
Three,
Mr.
Lordship, I
K.
appear.
Nayak for respondent number 3. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week. Petitioners are claiming their arrears outstanding pensionary dues / arrears payable to the petitioners were all retired employees of the GMC. So pendency of the writ petition shall not be a bar to release what?
Their outstanding dues.
Their outstanding dues in the meantime. List again after the returnable date. On 30 January.
Only 13 more also. Let it be on 23rd or 22nd. 39 we won't need him.
301.
January.
Oblige also.
May I please, Lordship? My lord, my father died on, my lord, 9/3/2019, my lord. Lord, I am claiming, my lord, my father's provident fund, my lord. I am married, my lord. And my lord, GPF amount, my lord. That is at page 15.
Are you eligible to claim?
My lord. Pension, I am not eligible. My lord.
Not eligible, my lord.
Pension not eligible.
She is married.
Pension not eligible, but my lord, the provident fund which has been lying in the account results of my that is I am liable, my lord.
Yes.
And against, she's claiming for compassionate family pension, but she is married, she is not eligible.
Compassionate family pension.
Yes, my lord, prayer is at page number 8, my lord. The prayer is C.
What about GPF?
GPF is managed by the accountant general.
Accountant General.
Yes, at page 15, my lord. The type copy is at page, my lord, 13, my lord.
Well, who's appearing for Accountant General?
Senior is on, my senior is not on the call today. We will take our instruction, Worship.
We call somebody else who's there, Accountant General. Yes. GPF.
GPF to divorce, you mentioned of the Morris. GPF to one.
I'll take instructions, my lord. If the post is pensionable, then only they will get the GPF amount. It's not, if it's
You
not.
get your instructions. Let him obtain instructions.
My lord.
Counsel for parties, petitioner claims to be the married daughter of late
Retirement date to Diana.
Gonga Vishnu Bin, who served as grade 4 employee under project manager soil conservation office, Sri Bhumi, Assam. Stop. According to the petitioner, she is entitled to the GPF amount, which has been lying with the department, and the same has not been released to the petitioner. Stop. That apart, the petitioner is also claiming compassionate family pension. Mr.
P. Hazarika.
P. Hazarika appears for
Respondent number 1 to 4.
respondents 1 to 4. Mr. B. Sharma appears for respondent Accountant General. Respondent number 5. Let the respondents complete their instructions and apprise the court on the next date fixed, list on 9th of January.
Yeah.
Extra copies be furnished
I'll
during the course of the day.
right now.
One of these applications, the issuance, not that this matter relates to non-issuance of why not transfer pay slip, my lord, the petition. You have, my lord, the failure to submit the charge report, my lord, putting the signature of, my lord, that, my lord, relieving and a relief officer, my lord. So, my lord,
You have been transferred.
yes, my lord, I have been transferred to.
You are serving as
Junior Principal, ITI,
Bongaigaon.
Bongaigaon, and my lord, I have been transferred to, my lord, Tinsukia, my lord. And
In the same post.
same post, my lord.
Then
Then, my lord, what happened, my lord, when that earlier incumbent, my lord, was transferred from the state post, my lord, they refused to, my lord,
in Tinsukia.
in Tinsukia, my lord, refused to hand over the charge, my lord. So, my lord, in pursuant of that, my lord, that letter had been, my lord, issued by page 21, that Accountant General, my lord. Page 21, my lord. complete দুটাই ডিভাই রিলিভিং সহি লাগে ঠিক আছে এটা ইমিডিয়েটলি সহি দিতে রয়েছে
There is an office memorandum.
and my lord,
There is an office memorandum.
yes, my lord.
You are under government of Assam,
Yes,
isn't
my
it?
lord.
There is an office memorandum where it says that you can take unilateral charges.
My lord, my lord, lost to kindly go to the page 24 for a moment, my lord. Page
24.
My lord, specific instruction direction is there, my lord, by the joint director. May I read, my lord? To so my lord, yes, my lord. With reference to the subject cited above, I am to inform you that a letter is received from the Office of the Accountant General Assam regarding issue of the transfer of pay slip of so the junior principal ITI Tinsukia. The search report submitted by the junior principal ITI Tinsukia were found to be incomplete as they lacked the signature of both the relieving and the relieved officer, which is not in accordance with procedural norms. Therefore, the Accountant General's Office has requested the submission of fresh search report or any special order validating the unilateral search assumption. In this context, as per communication received from so-and-so, junior principal ITI Tinsukia, it has been highlighted that upon his joining on 1st March 2024, he discovered that you had unilaterally handed over your search and joined ITI Borpeta without completing the formal handover process. Despite several attempts to complete the necessary formalities, you are reportedly declined to sign the search document citing your unilateral search assumption. This procedural lapse leads to administrative challenges and
We'll
delays.
issue notice here.
Yes, at present notice, my lord.
Council for the parties issue notice. That will go forward. Since the Mr. T. Sutia, C. Sutia, additional senior government advocate accepts notice on behalf of his respondents. 1, 2, and 4. Notices are waived. And 1, 2, and 4. And Mr. B. Sharma appearing with respondent number 3. Notices are waived. Extra copies will be furnished within a period of 1 week from today. Steps on respondent 5. I speed post within 1 week from today. Test again on 28th of
Yes,
January.
yes.
Yes. License.
I'd like to file one short affidavit. The fact remains is this, my lord. So far as the petitioner is concerned, he is the employee of the health department. He is under suspension. A DP is pending. And my lord, at the same time, my lord, his license is also suspended by the council.
No, but license is suspended for a particular period of time.
6.
That
No.
time has already gone.
No, my lord, there is a provision that it can be extended. They sought for some, my lord. No, I am saying, my lord, why? Because otherwise also he cannot go for private practice because he is under the health department now. DP is pending, he is under suspension. He has preferred an appeal also, my lord, against the order passed by the learned single judge, whereby, my lord, the restoration was not granted. That appeal has been, my lord, dismissed. Not dismissed, but the single judge's order has been upheld. And 4 months' time has been given to us to complete the DP. What I would say, my lord, lordship will grant us at least 3 weeks' time. The council will take a call, my lord, within 3 weeks.
Where is that order of suspension of license?
My lord, thus will find that order at page 25, my lord.
25.
Allegation was unauthorized absence. Page 25, my lord. It was issued on 12th of July, 2024. And 6-month period was over on 11/1/2025.
Yeah, that 6 months is gone long back.
My lord.
Was it extended?
No, there is no extension.
It was not extended. Punishment was not extended.
Well, in fact, legal opinion was sought for whether it can be extended under the provisions of the lordship. May kindly see, my lord, the act, my lord, for a moment.
after 1 year, whether it
No,
can be.
You can extend, you cannot extend is a different issue. The question is, as on date, is it extended or not? If not, then he's entitled to his name being incorporated there. Whether he can practice private practice or not is a different issue. But he has earned his right to have his name entered. Authorities on some ground thought it was not fit or will impose a punishment for suspension. Now, once that order is passed, unless there is a, by way of procedure, it is extended, he's entitled to have his name restored.
Let me file the affidavit, my lord, because otherwise also why I'm saying is, my lord, he is under suspension, he cannot practice. So that license, otherwise, my lord, it's not that, my lord, is urgently required.
No, who says he cannot practice?
Well, a government employee under suspension, how can he, my lord, practice?
If they are not paying me the subsistence allowance by law.
He under suspension.
No, cannot go for private job. Cannot go.
Is there a bar under the rules?
Yes, my lord. Any government employee, my lord, if he is put on suspension, he cannot go for different job, my lord.
No,
He
not
cannot
different job.
If
He's
he
a
is engaged,
professional, he is otherwise entitled to practice.
No, he's a government employee, my lord. That's it.
There is a rule that under some conditions, the doctors are allowed for private practice.
That's probably, my lord, there are certain options given, my lord.
Uh,
Non-practicing allowance and all something like that. That's it.
Well, if you can bring it by 7th of January, then all
My lord, I will
otherwise
bring
the
it by
party
immediately
court
on 5th itself, I will bring it on.
All right. Let him file affidavit, whatever he
Or
wants.
she will post it on Wednesday, my lord, immediately on
already the
21.
period is over on 11th
No,
of
no,
January
not 21,
25.
on 7th.
On 7, my lord, by 5th, I will file that.
Now you file it. Let us see what comes out on 7th. Third council for parties. The respondents submit that the instructions have been received and therefore likely file affidavit to bring the said instructions on record. And, respondent health department comment for some. Mr. Buddha appears for
NMC, my lord, respondent number 1 and 2.
respondent one.
DK Buddha.
DK Buddha. Let this matter be listed again on 7th, by which time the respondents may file their affidavit and bring their instruction from record if so advised.
Keep your obliged, my lord.
May I retain the para?
Make me your lawsuit. My lord, that was the last order with the fix for instruction, my lord.
I have received some instructions. Basically, it is a declaration made by late Prabhat Chandra Hendik, my lord, about his dependents. And the name of Tridip Karji, whom the petitioner claims to be her son, is there. Period number 5.
How old is he?
My lord, 2006 is birth. That means, my lord, it's near about
19 years.
19.
Mhm.
90s. Page 15 and Annexure 2 is the birth certificate of my son, my lord.
What is the claim of your?
Yes, my lord. My claim, lordship will find at page 3030, Annexure 8. I made 2 representation. This is last representation before as per number
No,
4.
these are representation, but what is your claim?
Yes, my
what
claim.
basis?
Yes, my claim, my lord. As per the OM, the lordship has recorded on last occasion, my lord.
You have to establish
I'm
that
second
you are the
wife, my lord.
wife.
Yes, that is.
Ah.
I have enclosed all the document, my lord.
What
Yes.
documents? Show us one document.
First of all, my lord, Annexure 1. It's a death certificate. That's
Mr. Counsel, you know what documents are necessary to establish
lord.
your claim as a wife.
yes, my lord. Then my
Where is your marriage certificate?
my lord, that marriage certificate, my Aadhaar card, PAN card, photo, bank statement. These are all my
those are not
documents.
documents to support your contention that you are the
2004,
legally married wife.
Since 2004.
You may be staying together, that's a different issue, but there is a set of documents which you'll establish. And then if you want to rely on these, then perhaps you should go to the civil court to get a decree that you are also the wife.
My lord, so far as regarding my wife, it is not disputed, my lord. And
Who has not disputed?
but I've also made party of the respondent, private respondent number 6, the first wife, my lord, here in this matter.
All right, then we'll issue notice here.
Yes, sir.
Heard counsel for parties issue notice returnable 4 weeks. Petitioner claims to be you are the second wife
Second wife.
of late Prabhat Chandra Karji. So according to the petitioner, she being one of the wives of late Prabhat Chandra Karji under the OM. Where is the OM?
Yes, my lord. At page 33 and Annexure 10,
31.
33.
33, OM dated 27th of October 2025 within bracket Annexure 10. The widows of the government servant are entitled to equal shares of family pension. So the petitioner claims that the private respondent number 6 being the first wife, she is receiving pension.
My lord, that much, I don't have any idea, my lord.
The authorities have not considered the claim of the writ petitioner that she is also one of the widows of late Prabhat Chandra Karji, along with respondent number 6, and is therefore entitled to equal share of family pension as per OM dated 27th of October 2025. Since the claims are not redressed, the petitioner is before this court. And let notice issue returnable 4 weeks. Mr. Odhikari appears on behalf of 1, 2, 3, 4, 5. Therefore, notices are waived. Extra copies be furnished within a period of 1 week from today. Steps on respondent 6 by speed post within 3 working days.
Yes, my lord, I have one prayer, my lord, in this matter, my lord. If the, my lord, in the meantime, the entire family pension released to the respondent, I'll be deprived, my lord. 50% release, maybe keep deposit me account, my lord. Otherwise, I will be deprived, my
No,
lord.
you
As per this, I
will
will
not be deprived. That can always be.
That may be kept open, my lord. Otherwise, my lord.
Any pension that may have been released to the private respondent number 6.
Yes, my lord.
Will be subject to such
Yes,
further
ma'am.
orders as
Yes,
we
ma'am.
pass to the present
Yes,
proceedings.
keep lawless, my lord.
May I have the lordship with a scripture instruction. I was sailing when transfer order, my lord.
What is it? Tell us.
My lord, I'm a commandant with
we
the
are asking the
ITBP.
respondent.
Oh, my lord.
Lordship, on 7, he is pressing on a document, annexure 5, page 52, that there is some direction that when there is a disciplinary proceeding, such a person should not be transferred, Lordship. In reply to that, Lordship, on the last occasion, Lordship directed me to obtain instruction that the original memorandum or office memorandum, on the basis of what this order has been passed, Lordship. So this is my instruction.
What is the relevant clause here?
Lordship, the first, second clause is the relevant clause, on the basis of what this. হিন্দি সব আছে।
Okay.
And in this case, Lordship, the next page, Lordship, page 2, clause 5, that the disciplinary action is yet to commence. It will be commenced only from the hearing of charges. The whatever till date that that article of charge, etc., that is the preliminary. Once he joined there, the hearing of charge will be there under Rule 43 to 45 of the ITBP rules, and thereafter the disciplinary action will.
You are posted where?
In Guwahati, my lord.
Guwahati. You are being sought to be transferred
To Dehradun.
Dehradun. Where are the disciplinary proceedings pending?
Guwahati, my lord.
No. That has been transferred to the same place where he is now transferred. Lordship, this
My
No,
lord,
but the witnesses and everything will be here.
no, Lordship, Lordship may kindly receive the.
Where is the show cause notice?
my lord, actually, that is the case, my lord. This is, my lords, they have not issued in show cause. They have conducted, they had formed a court of inquiry, which I had challenged. that Court of Inquiry had said like you proceed, they had recommended DP engagement, my lords. That very Court of Inquiry is under challenge by writ petition number, my lords.
So as on date, there are no show cause
But
notices.
my lord, there is no show cause, but my lord, kindly come to page number 19 of the petition. It's a translation, my lord.
19,
19, the petition. It says
yes.
they are found guilty so and so, and on page 2, my lords, ITBP for disciplinary action against them. Page 2, para 2. And page, on the next page, my lords, para 4.
They had challenged the proceeding in the first writ petition, but proceeding is not stayed, only the recovery part has been stayed. And on the second, Lordship had directed to provide him certain documents, and then liberty was granted to
As on date, the proceedings have not commenced.
Proceedings are under challenge, my lord. Though on black and white it is not there,
Not
but
there.
this letter specifically spells out, my lord, what are they trying to do, my lord?
Whatever it may be, but disciplinary proceedings will commence only on issuance of charge.
No, my lord, what
No cause.
in this case, what has happened, my lord? The Court of Inquiry, there's those proceedings, if they give to me, they will start the proceeding. Now they are giving me documents which are
You
deficient.
have challenged the outcome of the court of inquiry.
Yes, my lord.
If
Not the outcome, my lord, very constitution of the Court of
All
Inquiry.
right, very constitution and the consequential orders.
My lords.
Now, if that writ petition is disposed.
No, it is not,
pending,
it
It's
is
pending.
pending, my lord.
If the writ petition is allowed, then the very basis that you cannot be
Exactly.
transferred on disciplinary proceedings are pending
My
will
lords.
go,
My lords.
then you are entitled to be transferred.
My lord, now what will happen, my lord,
Absence of
when
service.
the moment I get transferred to Dehradun, my entire this exercise gets frustrated because I have to
Which
challenge it
exercise?
there again.
Which exercise?
This very exercise of filing this writ before this Honorable High Court, my
Why?
lord.
Why?
My lord, because that jurisdiction will go from there, because
No,
he's,
how will the jurisdiction?
my lord, because if the Dehradun, if they shift me to Dehradun, the DP will start there. I'll be a resident of Dehradun. The DP proceedings headquarter will be Dehradun. I lose my jurisdiction point, my lord. I lose a
No,
valuable time.
This is, you are challenging you are challenging the court of inquiry.
Court of Inquiry,
This court of inquiry has been passed in Delhi,
my lord. But while challenging, my lord, I was posted here,
maybe, so you challenge here.
my lord.
yes.
The matter is proceeding, at the time you had filed it, it is here.
My lord. But now if
The
I
course
have
of
a
action arose when you were posted here.
my lord, now
Therefore, you
if
had filed.
no, my lord, now my area of posting will be different.
Maybe, but the other writ petition will not become infractuous because of that.
Lordship.
But I may
If you
lose,
challenge your disciplinary
my lord.
proceedings, that you may challenge at your new place of posting if so advised. But
If
as of
I,
yet, there
if
is
I
no
may pray, my
disciplinary
lord,
proceeding.
if I may pray, this petition be tagged with that petition, my lord, then I can very well demonstrate what is going on. Because this lordship has,
Lordship,
We'll tag, but we'll have to vacate the interim.
yes,
order.
Lordship.
my lords.
We'll tag it, but we'll vacate the interim order.
But that will very well, that will affect me, my lord,
When is
because
the
if
petition?
once
When-
I go there, my lords,
When is that petition, when is the matter posted?
my lord, it was
No,
fixed.
not
no,
fixed.
no,
Affidavit, I have sent it for vetting, supposed to file.
my lord,
as soon
until
as
unless
it
my
is-
lord will hear these both petitions together, until then, my lord, I may be given some protection, my lord.
Your protection.
My lord, the
You are-
moment
you are-
I change my post office,
No.
the moment I change the moment I'm shunted out of Guwahati to Dehradun, this point of jurisdiction will come.
No, Lordship, Union of
Point
India,
point of jurisdiction in respect of the other petition will not come. You are questioning the very correctness of the court of inquiry.
My lords.
Right?
Then let that be decided first, my lord.
Ah,
10
let it
days
be
should
decided,
proceed, but
but then- but
no, my
then
lords. Because the
your-
very basis of my transfer,
No. Under as on date, what is the ground to give you the benefit of an interim order?
my lord, the ground is, lordship has rightly concluded that the very basis is that court of inquiry and its outcome. So my lord will see these documents, this very transfer, these attachments, all the foundation of this, all those exercise is that court of inquiry.
Correct.
So
You
until
get
unless
an-
that is decided,
You get your appropriate interim orders in that matter, that until it is decided, no disciplinary proceedings. You are questioning the order of transfer on the ground that there is a circular which says that when the officers are under disciplinary proceedings, they should not be shunted out. As on date, there is no disciplinary
if
proceeding.
lordship gives me one chance, my lord, lordship will list this matter on Friday, tagging with that, my lords. because that petition is not with me.
Friday is the last date, Lordship. So
Let it be
he-
Thursday, my lords. If that petition is tagged together, there are materials
In
there.
that case, there is
my
no
lord, my lord.
stay, Lordship. Only the
I understand,
recovery
that
has
there is
been
no
stayed.
stay. But if that petition is tagged, I can spell out I can demonstrate, my lord, what is actually going on. Because I have materials annexed to that petition which shows, my lord, the very mind.
That petition is not questioning any departmental proceeding.
It's questioning, my lords.
No, no.
My lord, can you come to page number 16?
That is questioning only the order passed by the Court of Inquiry.
In that case, Lordship have to see the second order. Lordship, 29A,
No, no.
30,
Lordship will kindly come to 29/8/25 order.
that is the first.
Page.
Page 15 it starts. 16, my lord, will kindly come to paragraph 4. Paragraph 4, my lord.
Yes.
Disciplinary proceeding has been initiated, my lord. That was there, my lord. We have demonstrated there, my lord.
Constitution of Court of Inquiry was illegal.
Yes, illegal, and my lord, if we go, my lord, further, my lord, it is further contended that the office order that is so and so has been initiated. So that document is very vital. So bring out to the document, my lord. I need this petition to be tagged with that other one.
Thereafter, the second read petition, Lordship may kindly come to page 25.
Second, my lord, it was limited, my lord. The ground was very limited. That supply me
Because we have
documents.
issued a transfer order on 23/10/25, challenging that, Lordship, he had filed a second read
No,
petition.
this petition is pending.
Yes.
First one is pending.
Pending. There is a reference of some disciplinary proceeding initiated by office order. What is that office order? 22/7/27? 27.
26, my lord. It might be 25. It's wrongly recorded.
25. Where is that?
My lord, in this petition is not there.
It's not there.
That is the reason, my lord. Today I am a bit handicapped. If it is tagged with that, I can bring it up, my lord.
Yes.
But Lordship, here his only prayer is that comes from the second read petition, Lordship. Second read petition, we have transferred him on 23/10/2025, challenging that.
Is there any proceeding pending or not?
That I have already stated in my instruction, Lordship. It will be,
Instructions are all right, but there is a judicial order where some document is referred to.
that document we have submitted him and the proceeding will start now, Lordship.
We
As
don't
per
know.
section Rule 43,
Madam, see the order. It says this was a contention, right?
But might be a contention, but it just taken into cognizance, my lord. And based upon that, my lord, that order was passed.
that is why there is no stay order in the proceeding, because actually it was not, only the recovery part was there.
Yes, tell us when you want it. This writ petition, the counsel for the petitioner submits that the departmental proceeding which are initiated, and you are challenging the departmental proceedings. No.
In this case, not.
No.
And because of which the present writ petition has been filed assailing the transfer order dated 23/10/2025 along with the movement order dated 17/11/2025. Is on the premise that once a departmental proceeding is initiated as per the policy prescribed, as for the policy of the ITBP adopted by the appropriate authority, the officers concerned are not to be transferred out. Counsel for the petitioner has referred to the office memorandum dated 17/11/2025. It is the contention of the counsel for the petitioner that this disciplinary proceedings initiated against the petitioner is premised on the Court of Inquiry conducted by the Director General ITBP by the office order dated 23/10/2025 against the writ petitioner and other officers, whereby the DIG SHQ Dehradun ITBP Police was directed to take disciplinary action as commanding officer within 60 days against those officials found guilty. Stop. The learned counsel for the petitioner submits that this office order dated 23/10/2025 is presently being challenged and is pending in WPC 5016 of 2025. Stop. Copy of the order dated 29/10/2025 passed in WPC 5016 of 2025 is also enclosed to the present proceedings, whereby notice in the said writ petition has been issued. Stop. Referring to para 4 of the said order passed by the coordinate bench, counsel for the petitioner submits that there is an office order dated 22/7/2025, which has been referred to by the writ petitioner in the said writ petition to contend that disciplinary proceedings have been initiated. The counsel for the central government counsel representing the respondent, on the other hand, disputes the contention of the writ petition. Stop. It is submitted that as on date, disciplinary proceedings have not been initiated. Show cause has not been issued.
Lordship, as per rule 45, Lordship may kindly page 2 of my instruction, that it is that in the instant neither charges have been framed against the petition nor the hearing under rule 50. It starts only after hearing of charges. Charges have not yet framed.
The learned CGC, referring to the instructions received, further submits that the charges have not been framed as on date, and therefore the contention of the writ petition of that disciplinary proceedings have been initiated, and therefore in view of OM dated 17/11/2025, the petitioner cannot be transferred is an incorrect contention made on behalf of the writ petition. Stop. Where in order to decide this issue as to whether the disciplinary proceeding is pending at present, on the request made by the counsel for the petitioner, matter is directed to be listed along with WPC 5016 of 2025. On which date?
9 January.
9th of January. To enable the counsel for the petitioner to place before the court to support his contentions that disciplinary proceedings have been initiated against the writ petitioner pursuant to the directions of the passed in the court of inquiry by the Director General ITBP, and as a consequence whereof, in terms of the OM dated so and so, 17/11/25, the transfer order and the movement order ought not to have been issued by the respondents, list accordingly. Respondents may, in the meanwhile, file the parties may exchange their pleadings in the meanwhile.
So, in the second case, there is a stay, but I pray for a status quo, Lordship, because he is on.
The interim order is passed, Interim order passed will continue till the next date of decision, 9th of January.
All right.
Wait, please, your lordship.
In this case, I was supposed to take instruction also. As per my instruction, some more time is required for it.
Council for parties issue notice returnable 4 weeks, MSRDB. Then it's CGC, appears and represents all the respondents, therefore notices are waived, extra copy will be furnished within a period of 1 week from today.
May I pray your lordship, this matter may be fixed in the last week of January because he will retire by 4/2/2025 as per the order, your lordship.
28th of January?
Deep.
It's on 28th.
Deeply.
My pleasure, lordship. Petitioner has challenged his rejection of his candidature in the recruitment of constable process, lordship, 2025.
Height.
No, height reason, lordship.
Height.
The lordship will find page 45 is the impugned rejection order.
What is the cutoff?
165.
165.
165.
Where is the RME report?
Lordship, here no RME is conducted because once a candidate is rejected in the PST.
Where is that finding?
Lordship, page 145. 45. 164.6 cm.
Wow. 164.6 will be rounded off to 155.
Yes.
Yes, similar judgment order was passed by the.
Yes,
You have that order?
has already held it.
You have a copy of that order?
Yes, Lord. There are 11 to 19 as of 11.
I think this bench has also disposed of some.
No, this.
Height?
Not in respect of height.
So you have gone through the order.
Yes, lordship.
Heard, disposed.
May I pray for fixing a time frame for the detailed medical examination?
Whatever is there in that order.
Lordship.
If it is there, it is there. If it is not there, we are passing similar orders.
But in that particular judgment, no time frame has been fixed. Because now they have started the recruitment of 2026. 2025, the review medical examinations are over. Almost over.
EME and RME are going on.
So therefore, this can be
Within time.
Directions be complied within period of 90 days from the date of receipt of a certified copy of this order.
Lordship. All right.
My pleasure, lordship. Matter pertains to appointment of Gaubra, lordship.
Gaubra.
My lord. My lord, I was aggrieved by the selection list, my lord. Earlier I preferred a writ petition before this honorable court, and same was disposed of on 22/9/2023 because there was an alternate remedy, my lord. So I prefer the alternate remedy, my lord, first before the Commissioner of Divisions, but that forum was abolished and the jurisdiction was thereafter vested on the respondent number 3, DLR, my lord. My appeal was registered as DLR Appeal 135/2025, and my appeal was allowed, your lordship. And the copy of the order, my lord, it begins from page 39. Page 39 is the order of the Director of Land Records and Surveys, your lordship.
Yes.
My appeal was allowed by the reasoning given at page 41, para 2, residency and land ownership of respondent number 5, who is arrayed as private respondent, pro forma respondent number 7 in the writ petition, my lord. The clause 7 of the terms and conditions, my lord, which was one of the clauses in the employment notice, your lordship, that condition was violated by the private respondent, your lordship. So on that ground, his appointment was set aside, your lordship. Thereafter, my lord,
Appeal was filed by you.
Appeal was filed by me, my lord.
You are not the selected candidate.
On the merit list, I'm serial number 2, your lordship.
So it was set aside.
It was set aside. His appointment was set aside. On page number 42, operative portion, my lord, the respondent number 4, who is the DC of Nagaon, my lord, he was given a direction, DC Nagaon, to take necessary action accordingly. Now, my lord, one of my prayers in my appeal memo was to consider me for appointment. to give a direction to DC to consider me for appointment, your lordship. Since that direction was not given, your lordship, to modify this order, I preferred a review, my lord, before the respondent number 2, your lordship. This review was filed on 21/11/2025. Till date, my lord, it has not been registered, your lordship. No registration number, no hearing has taken place. All I have received, my lord, is a receipt number. I have annexed the review petition, your lordship. It is at page number 43, my lord. Page number 43, my lord. That is the review petition, my lord. It was filed on 21/11/2025, 10 days after the appellate order was filed, my lord.
Then let them obtain instructions, this revenue standing council.
Status of the review.
You obtain the status.
She has also issued a re-advertisement for the post, your lordship, on 1/12/2025. That is the problem, my lord.
Are you challenging the advertisement?
Yes, I'm challenging. That is my prayer is at page 29. I have made 4 prayers, your lordship. At prayer A is, my lord.
When was the selection made?
Selection was made, my lord, on 11/3/2023.
23. So the select list has expired.
Yes.
Otherwise,
I had, my lord, filed the appeal, my lord.
you may have, but was the tenure of the select list extended? I mean, I don't know if there is a rule which says the validity.
Normally, my lord, there is
period of
1 year period, my lord.
1 year.
1 year. But since
But
I've
while
been filing the
while
the
filing the
proceedings,
appeal, was there any, or allowing the appeal, there was no direction that the state select list, period of select list will be will be extended.
that direction was not given, your lordship. That direction was not given, your lordship.
Therefore, they have gone for a fresh selection.
Otherwise, Lordship, there is no impairment in the order of appellate forum, Lordship, because appointing and removal authority is the DC. DLR has hearing and.
No, that is all right. Who is agreed that he was number 2?
Lordship.
Yes, yes.
He's filed an appeal. Appeal is also allowed.
Allowed. But his contention is that he was not directed to appoint, Lordship.
So therefore,
That power is vested only upon the DC, Lordship.
so
The DC, DLR can observe this. That
you find out the status of what has happened to the review petition.
Review. That can I can do.
And where is the advertisement?
Advertisement, my lord, is at page 37, your lordship. Page 37, my lord. This advertisement is of 1/12/2025. And my lot is also there, my lord. Lot number 4.
Page number 37.
Page number 37.
Serial number?
My lord, serial number, it's under Kanpur, my lord. Serial number will be 44.
Kothiatoli.
Hmm.
43 plus start over, 40 plus start over.
Which village?
Village is Rangbang, Horupatha.
Lot number 4.
Lot number 4. It is
Number 4.
43.
My lord, I may submit, my lord. The candidate who was selected, my lord, and appointed, he never satisfied the eligibility criteria, my lord.
Whatever it may be, that has been answered by your appeal.
My lord.
We are not hearing that.
I am at serial number 2, my lord.
You
By
answered.
far, my lord, I am the most eligible candidate.
You show us that from the said select list after expiry of the validity or after this
Since I
period.
prefer the remedies, my lord, within time, my lord, would it not extend the selection, the
For you
limitation
to
of the
urge-
selection?
It is for you to urge and satisfy the court. Whether it extends or not, it is for you to examine the law and tell us.
My lord. On this point, my lord, I will.
You have to. When can you get it? Status of appeal.
Status of appeal, Lordship.
Status of
Review.
review.
Status of review, Lordship. Wednesday, Lordship. Thursday, Lordship.
Thursday.
Lordship.
Thursday?
advertisement, your lordship. If
You satisfy us that your right for being considered for appointment from the said select list is still there in view of the order passed by the appellate court. Appellate court did not say select you, appoint you.
No.
Appellate court directed the DC to take appropriate
Action.
So DC has sought for an advertisement. Who has given the advertisement? Deputy Commissioner.
This is district commissioner has the authority to appoint and
You
remove.
show us any law which says that in view of the appeal being allowed, the validity of the select list
Continue.
is to be understood to have been extended. That's the issue.
Yes.
Serve extra copies to the respondents today. List on Thursday. Enabling the Mr. S. Doctor for revenue and Mr. J.K. Goswami for state respondents to complete their instructions. Mr.
H.K. Burwa.
H.K. Borwa, yes.
44 similar, my lord. Different lot, different gown.
But same issue.
Same issue.
All right, Thursday.
Obliged.
With your lordship. My lord, I appear on behalf of Mr. T.J. Ahmed, your lordship. This matter may come up for admission hearing, your lordship.
We have filed affidavit one.
Yes, lordship.
We have
It
already
is
filed.
submitted that the pleadings are exchanged.
Lordship.
Issue rule, matter be listed for hearing. The
Lordship.
month of February.
Keep your wish.
There has been compliance, my lordship.
Huh?
There has been compliance, my lordship. Of the
Order has been complied with.
Yes, my lordship.
It is submitted by the counsel for the petitioner that the directions contained in the order dated so and so, passed in WPD so and so, has since been complied with. Writ petition accordingly, contempt petition accordingly stands closed. Notices issued stand recalled. MS
Escolita on behalf of B. Sharma.
Escolita on behalf of B. Sharma appears on behalf of which respondent? On behalf of the respondent.
Sole respondent.
16 also, my lordship, it is similarly situated and it has also been complied with.
Complied.
Yes.
All right, same order. Disposed, complied.
Obligement.
This case, my lord, they have mounted a challenge to this judgment of the single judge, my lord.
Lordship,
Read
we
appeal.
filed our affidavit, your lordship.
No, no, I took one read
Is there an
appeal.
appeal?
They have
Delay-
instituted read appeal, my lord. Delay has
Appeal
been
is pending.
My lord.
Appeal is pending.
Lordship.
Appeal they have filed, man. Delay has been known.
It
Lordship,
is submitted at the bar that against the judgment and order dated
my lord, 22/6/22.
22/6.
Oh, no, no, much, no, no, no. It's 10/5/24. There's a review.
They have filed it against which order?
That review order.
So it can't be against the review order alone. Subsequently, some review was filed.
Yes, yes, my lord. They had filed one review.
That pursuant to the directions contained in the order
Yes, yes.
dated 22/6/2022, passed in WPC 5172 of 2016. A review petition was filed by the respondents, which came to be rejected. Therefore, presently, a writ appeal has been filed by the Union of India, which is presently pending disposal. Where in that view of the matter be listed after 8 weeks. The counsel for the parties are at liberty to apprise the court regarding the disposal of the appeal, if any, in the meantime.
All right.
This my lord. Well, service so far as respondent number 9 is not complete, my lord. When they get office report.
So all are served.
1 to 7 are appearing, my lord. On the basis of last order, actually, last order says that notice has to be served on respondent number 8, but 8 is already appearing, my lord.
9, my lord.
9.
9 is important, my lord, because it's a private
Yes.
individual, my lord. Main dispute is between the
9
9 and my
Respondent
lord,
number.
petitioner.
So how do you intend to take steps by Dusty on 9?
Registered post and dusty, my lord. Full fair.
Right. As per office note, pursuant to notices issued, steps have been taken on the respondents and respondent 1 to 8 have been served and are represented by the council. Stop. However, private respondent number 9 has not yet, the service report is awaited, nor is the respondent represented by any council. Stop. Therefore, the petitioner is directed to take fresh steps by registered post on respondent 9 within 1 week from today. Stop. Dusty. Service by way of Dusty is also permitted, subject to the same being routed through the registry of this court. Mr. R. Dhor for
PWD, my lord.
respondents number 1, 2, 3, 4, 5.
My lord.
Mr. Boro for Rabha. Mr.
6 for respondent number 6.
For respondent number 6. And MS S. Borua for 7. Mr. Nayok for respondent number 8. List after 4 weeks.
My lord.
All right. 4 weeks, give a date. 19th January.
My lord, in respect of resolution number 6, my lord, service is completed.
As per office note dated 28/8/2025, service on respondent number 6 has been completed. Matter be listed. However, none represents the respondent number 6. MS S. Borua, learned.
Lord, otherwise my prayer is very limited.
Council appeals for the other respondent. Yes.
Prayer is very limited.
What is your prayer?
Lordship, may kindly direct the respondent authority to consider the representation submitted by the petitioner before selection and appointment. Your Lord.
The petitioner is agreed that his representations dated 29/4/2023 and 25/5/2023 filed before which respondent? Deputy Commissioner.
My lord.
Before the respondent authorities have not been disposed of. Considering the limited prayer, this court considers it appropriate to dispose of the present writ petition by directing the, where are your representations? Page number?
Page number 21, my lord, 121 and another 28.
21 and
28.
28. To dispose of the representation dated 29/8/2023. Direction to respondent 5.
Respondent number 5.
To dispose of representation dated 29/8/2023. And also to respondent number 4. To dispose of the representation dated 25th of May 2023. Stop. Needless to say, any orders that is passed by the respondents. While disposing of these representations, copies thereof shall be served on the writ petitioner. Stop. If in the meantime any such order has been passed disposing of the writ petitions, representations, then a copy thereof shall also be served on the respondents disposed. This is item number 20.
I am appearing for 1 to 5.
MS S. Borua appears for respondents 1 to 5.
Some time may be frame, you know.
The entire exercise will be completed within a period of 60 days from the date of receipt of a certified copy of this order.
Blessing, master blessing.
Yes.
Pleases your lordship. Lordship, I am appearing on behalf of Mr. S.P. Chudit for contempt number 3. Lordship, today we have received the up-to-date instruction and we would like to place it in the form of affidavit. Kindly 1 week time may be given, Lordship.
But they are directed to place the compliance report.
Counsel, Mr. I. H. Soikia appears for the writ petitioner. MS
B. Devi, Lordship.
B. Devi appears on behalf of Mr. S.P. Chaudhary for respondent number 3. Writ petitioner, no contempt petitioner. The learned counsel appearing for respondent 3 submits that updated instructions have been received. She would like to bring it on record by way of an affidavit. Stop. She prays for 2 weeks' time. Stop. Considering the prayers made, let the matter be listed immediately upon reopening on 6th of January 2026. Bless them.
But we will. Herein, your lordship, I have already supplied the amended cost title, your lordship.
You have?
Amended cost title, yes. And it is also reflected in the.
Pursuant to the order dated 3/4/2024, amended course title has been filed. Registry has also made necessary note thereof in the note sheet by the note dated 19/09/2024. Stop. Amended course title is for what?
Respondent number 9, it's a.
Huh?
The name of the respondent number 8 was added by his name, your lordship.
8.
8.
Issue notice to the newly inserted respondent number 8. By speed post within 1 week from today. Mr. A. Chakraborty appears for the respondents.
4 lordship.
Respondent
4
4.
lords.
List again on 9th of January.
Problem.
No, sorry, sir. It will be on 19th of January.
Yes.
Order complied.
Lord, but so far as we are concerned, Lord, our part we have complied. And there was a direction by your lordships, my lords, there, the EPF authorities, my lord, they had to.
Service report is awaited.
But
As
can
per
I,
office note 10/12. Service on respondent 3.
I
took steps on in time.
It is awaited. Service report is awaited.
can I point out one thing, Lord? Respondent number 3, Mr. R.N. Srivastava, was an employee of AAI. He retired in the year 2017-18, my lord. So, my lord, he has been wrongly been implicated. My lord, I have taken instructions so far as respondent number 3 is concerned.
File applications, we don't know. As per, there is a
No,
there is a direction to take steps.
yes, I.
So steps he has taken, service report is awaited. We'll have it in January.
January 1st week.
First week. As per office note dated 10/12/2025, service report on respondent 3 is awaited. Mr. PCR Medi appears for the petitioner, Mr. R. Dubey for respondents 2 and 4.
But I have one prayer for your lordship. Lordship, we had filed so far a respondent number 2 is concerned and 4. 2, we have filed a detailed affidavit. However, inadvertently, my lord, some of the annexures have not been annexed in that. My lord, your lordship may permit just to annex those.
Let the matter be listed again on 9th of January. Office will indicate the service of notice on respondent number 5. Sorry, respondent number 3. Mr. Dubey further submits that certain enclosures to the affidavit which is filed on behalf of
Respondent number 2.
respondent 2 were inadvertently left out. You'd like to, he seeks liberty of the court to bring those on record by way of an additional affidavit.
Oh, my lord, I can annex because there is annexure has been mentioned. Inadvertently, it has not been annexed.
You bring it by way of an affidavit. Prayer made is allowed, list again on 9th of January.
Your Lordship, here the committee has been formed for verification of the documents for granting of the minimum the pay scale to the petitioners along with our Lordship. Here the department is just seeking some time so that they can place the compliance report on the next date. So Lordship, any date in January, Lordship, so that the petitioner's case at least I can keep an update, Lordship.
Yes.
What to do, my lord?
Lordship, I'm just seeking January first week, Lordship. I'll play.
Right. 9th of January.
Lordship.
NS Thakuria appears for the petitioner, Mr. A. Chalia appearing for the
Respondent number
finance,
5.
Mr. P. Hazarika for respondent 1 to 4.
1 to 4, yes.
Mr. Chaliha submits that the committee has been constituted for verifying the particulars of 1231 master roll workers.
Yes, Lordship.
Including the present petitioner. He says that the process is underway.
Yes.
But on the instructions, further time has been sought for by the department to place before the court the status of the verification.
Lord.
So, as agreed to, as prayed for by Mr. Chaliha, lists the matter again on 9th of January. Enabling him to place before the court the report of the committee regarding the verification
For the petitioner only.
for the petitioner.
Lordship.
Deeply obliged.
Item, my lord, petitioner, my lord, press for similar order, my lord, already it is a covered case. I have annexed the order, my lord. He was appointed as a Mondal, my lord, honorary basis, page 27, my lord, of the repetition, my lord.
What?
Page 27,
Which order?
my lord, page 27 is the appointment letter.
No, you are pressing for similar order?
Oh, yes, my lord. I have annexed here, in the page 90, start from
You
page
have
90.
filed an IA, why have you filed?
IA, my lord, because my lord, as one new advertisement was published, my lord, in the year 2023, I also applied there, my lord. But following letter was issued to me, my lord. But in terms of the earlier advertisement interview, my lord, I got appointment letter, my lord, also on honorary basis. I prayed for my lord, coverage and the my lord, similar relief by the judgment of this honorable court, page 90 onwards, my lord. Already order has been passed. To
Why, what orders are to be delivered today? Why is it for orders?
But Lordship, kindly see page 108. It is not covered case. 108, paragraph 13. This court, on taking into account of facts and circumstances, is of the opinion that there may not be any issue of legality with the fresh advertisement while recruiting for the post of Gaon Pradhan. The lots where the petitioners have been discharging their duties on the strength of their initial appointment as Gambura should not be made part of the said recruitment process. As a corollary, it is directed that the petitioners be continued to discharge their duties as Gambura, Gaon Pradhan in terms of the present rules and incorporated in the advertisement dated 20/24, 2023. The aforesaid direction is however restricted to only to the present petitioner who are 66 numbers in the equal number. Only those petitioners only.
But he also got
No,
appointment.
no, he is not in a part of this also.
No, no, my lord, I have annexed here, my lord. Kindly peruse your lordship, same my lord letter.
We'll keep it for admission here.
Yes, my lord.
My
To
lord,
be
those who are, my lord,
listed for admission on 21st January.
Yes, my lord.
Mr. T.C. Sutia for the state respondents and Mr.
2, 3 and 4.
J. Hendick for
one, lord.
respondent 1. T.C. Sutia for 2, 3 and 4. Yes.
I will ask my lord.
May I please your lordship? Lordship, this is file for correction of an order, lordship. Although it's a 2023 order, but lordship may find the relevant portion at page 14. The second last paragraph. If all the relevant document as called for from the Office of the Director of Secondary Education are found in order, the Secretary to the Government of Assam Department of School Education will pass necessary order giving regularization to the petitioner from the date of the petitioner was adjusted against the sanction post, that is from 1/3/1980. At present, the petitioner already retired, lordship, but subsequently, lordship, he had submitted all the documents, and except one date, lordship may then come to page 16. Recent
1/6.
This is a communication from the Secretary Government of Assam School Education Department to the Senior Standing Council, from where I came to know that second paragraph, lordship. Further, in the report submitted by the DSC Vice Letter so-and-so, it has been mentioned that so-and-so was engaged to work as Manipuri language teacher by the managing committee to the provincialized local Jugai Mathura High School, Kachar, in the scale of pay so-and-so on 29/8/86 under the scheme of educational facilities to linguistic minorities as per government letter number so-and-so dated 30/1/3/80. Subsequently, he joined there on 1/9/86. Consequently, so-and-so was adjusted against the sanction post by the then Inspector of Schools so-and-so by the order dated 26/10/89. Hence, given that as per records, the actual date of the petitioner adjustment against the sanction post is 26/10/89 and not 1/3/80 as recorded by the Honorable Court. As such, there appears to be a cause for preferring a review so-and-so. But lordship, there is no dispute. We admitted that he joined on 26/10/89. The post was sanctioned on 1/3/80. That is what is reflected in the order. But he had joined in the sanction post on 26/10/89.
Was this document before the court?
Which one, lordship?
No. Page number 16, which you have just read.
This is this year, lordship, just few days back.
No, what we are saying is, according to your records, he joined from 26/10.
Yes, that is there. 26/10 last page, lordship, page 18.
Correct. But this is not a case. You see, ordinarily you have to file a review. If this document was not available before the court when the order was
No,
passed.
it was there.
It was there.
It was there.
Who's for the petitioner?
I'm for the petitioner.
You are for the petitioner.
You are for the petition. That document was annexed 2 in the writ petition.
All right. Then. Yes.
In that regard, we have no objection regarding that.
Heard counsel for parties, this IA has been filed seeking correction of the order dated 14/8/2023, passed in WPC 6637 of 2021. Stop. It is submitted that This court by order dated so and so while disposing of the writ petition. Had directed inter alia, page 14 of in marked portion to extract puri italics of DD. Huh? Learned counsel for the petitioner by way of the IA submits that the date of adjustment of the petitioner ought to have been 26/10/1989 and not 1/3/1980 as recorded in the order. So this, the learned counsel for the applicant petitioner has submitted on the basis of a communication dated 26/10/2025, which has been submitted by the Department of School Education. Stop. The said communication is enclosed to Annexure B of the IA. She submits that there is no dispute but in this regard, stop. At the time when the writ petition came to be disposed of by order dated so and so, this document was available before the court. These documents, this document was there.
My document was there, not this one. 2610 was annexed to.
Document, appropriate documents to show that the period of adjustment of the writ petitioner against the sanction post, he will be from 26/10/1989. However, by oversight, perhaps this was not referred to, and accordingly, the court came to dispose of the writ petition recording 1/3/1980 as a date for adjustment of the writ petitioner. Stop. Where counsel for the respondent does not object to the prayer made. In that view of the matter, this IA stands allowed. It is ordered that the date the petitioner was adjusted against the sanction post as referred to in the order dated 14/8/2023 passed in WPC 6637 of 2021, should be read as 26/10/1989 instead of 1/3/1980. Stop. This order shall be read together with the order dated 14/8/2023 passed in WPC 6637 of 2021. IA accordingly stands allowed, disposed of.
Much obliged.
IA has been preferred on the strength of the order dated 24/4/2024 passed by this Honorable Court. IA has been preferred
For what?
for implement of the parties.
Implement.
Implement.
Why is it to be implemented?
As per order of the Honorable Court, because at the time of hearing, the counsel appearing for the respondent submitted before this Honorable Court that the original respondent was already abolished, and subsequently DLR presently he is posted as the party concerned, and subsequently he has been made as a party.
He is no longer in the office.
No, my lord. Earlier respondent, no.
Third counsel for parties, Mr. So-and-so, learned counsel for the petitioner, submits that the respondent, sole respondent, arrayed in contempt petition number so-and-so, Nambu deliver Sri so-and-so, is no longer has since demitted his office as Commissioner Lower Assam Division, Panbazar Stop. The learned counsel for the applicant, contempt petitioner submits that the opposite party in the IA is presently the Commissioner Lower Assam, and therefore, since the directions contained in the order dated so and so passed in WPC so and so has not been complied with, the opposite party respondent is required to be added, is a necessary party and required to be added as a party respondent. None represents the respondents in the contempt petition. Considering the submissions made by the applicant, so and so, who is arrayed as opposite party number so and so, and is stated to be presently the Commissioner Lower Assam, who was directed to comply with the directions contained in the order dated so and so passed in WPC so and so. He is considered to be a necessary party and thereby arrayed as a party respondent. So I accordingly allow, disposed of. The applicant will file amended course title in terms of the present order before the registry within 2 weeks from today. In contempt petition, you write, in view of the order passed in the I, Sri so and so is arrayed as respondent number 2. Stop petitioner will file amended course title within 2 weeks from today. Matter be thereafter listed again on 19th of January.
No, please. Lordship, IA is for condoning a delay of 61 days in filing a restoration application.
We'll issue notice today. We'll have to issue notice. Yes. Heard counsel for parties issue notice. Steps of the respondent by registered post within 1 week from today. Matter be listed again on 19th January.
Obliged.
May I please, your lordship? Lordship, 83 days delay to file the restoration petition.
Yes.
Lordship, I am for ACC, lordship.
Any objections?
No, lordship.
Heard counsel for parties issue note. This, what have you filed here? Contempt. Sorry, what have you filed?
File of IA for
Condonation of delay for what?
restoration, filing the restoration petition,
Okay. The writ petition was dismissed for non-prosecution.
my lord.
No, but writ petition was disposed of by recording that nothing survives in the writ petition.
Oh, my lord.
Yes,
Record to
19/9/2024, writ petition order.
Before the honorable, but due to the health condition. No, my lord, it was typographical mistake. It was, this was, order was passed and we have filed contempt also.
You're seeking restoration pursuant to which order?
My lord, this order, WPC number 6313.
Yes, in what is the date of the order?
My lord, that was that wrongly, my lord.
Huh?
That was wrong one. 19,
19/9.
my lord. My lord, we will correct the
What is the date of the order?
order dated,
You don't have the copy of the writ petition with you.
my lord, I know. 6313.
We have the writ petition. What is the date by which it was dismissed?
To order restoration. Order 3019.
So for the petitioner will, the request matter stands deferred to be listed after reopening. You come back after reopening with all the.
Wait, we have the order. You have the order, my, I have. We must do this.
Copies of your economic.
This is a different order. What are you giving us? This is 3016.
Madam, give me some time. I will.
Then you come back after reopening. Do it properly or. All right, after some time.
No, after something.
Yes, second half, 2 o'clock.
May I please, Your Lordship? Lordship, this is filed for striking the name of applicant, Your Lordship, Accountant General. From the.
In the writ petition, Your Lordship, Accountant General has been implemented as respondent number 6, Your Lordship. This is the writ petition for regularizing his work there.
Does it petitioner pray for regularization of service? Here,
Yes, we know. Any objections?
Yes, Your Lordship. The thing is that if my service is regularized and I get pension, Your Lordship, AG has, there has to be a direction to the AG.
For
That's
what?
what was
For
made.
what?
For releasing the pension, Your Lordship.
So you are claiming for
Regularization.
regularization.
We have retired from
So,
service, Your Lordship.
in regularization, Lordship, we do not have any role in Lordship. For that, for his person.
He
should
is
come-
already retired.
Lordship.
He is asking for pension. Pension is not granted because he is not regularized. Now he is asking for a direction for regularization. If it is granted, and if the court wishes to grant,
That will.
then a consequential order for accountant general will have to be issued.
Yes, Your Lordship.
But
WPC
here, the WPC is specific credits for regularization of the service of the petitioner, Your Lordship. With respect to pension, Your Lordship, he will face cross of action will arise, Your Lordship.
All right, you file your objection, heard. Counsel for party issue notice in the IE.
One vital department is not included, my lord. The finance is not a party.
The opposite party submits that you would like to file objections. Prayer made is allowed, list again after the returnable. On 28th of January. 28th of January.
Much
Mr.
obliged.
Rathore for
PWD.
BW.
For admission, item 33.
So 33 and 34 are similar with regard to appointment of arbitration. Which they have initially considered and however they denied in subsequent election.
Yes, objections.
Not objection regarding only one clause, my lord. There's one clause to 25. 25. My lord, at page
19 is number 19. Objection is at page 19, lordship. Page 64, annexure 19. Objection is at the second page or second paragraph, lordship.
Yes.
They have objected only to the fact that we have deferred the claims after 90 days as per the clause 64, once surplus Roman 4, lordship.
Have you filed your objections?
not objections, we are not filing, my lord.
Lordship, it was-
You want to file
Yes,
objections?
yes, my lord.
File it. Let the objections be on record. Counsel for respondents pray for and is granted 2 weeks' time to file their objections. This matter again on 19th of January.
Yes,
Mr. D. Decca for the petitioner, Mr. H. Gupta appears for the respondents. Both the matters are on the same orders.
Right, lordship. This is with regard to appointment of arbitrator, my lord. Section
We'll
11.
take up this matter in the second half. This matter will require some hearing. Second half, 2 o'clock.
May I please, your lordship?
Yes.
May I please, your lordship? Lordship, this matter pertains to appointment of lordship, arbitrator. Lordship, what has happened, lordship?
Notice issued.
Notice is.
Affidavit we will file, my lord, because.
You want to file?
Yes, my lord.
Right, heard counsel for parties, the Mr. H. Gupta, learned CGC, submits that you'd like to file objections. The prayer made is allowed, list after 2 weeks, list on 21st of January.
My lord.
May please, your lordship. Lordship, they file the affidavit today.
Today file.
We need 2 weeks' time to file a reply. His lordship may kindly fix the date.
Your name?
Yuvraj, Y count.
Mr. Y. Count, learned counsel for the petitioner, submits that affidavit has been filed and served on the petitioner. He prays for
2 weeks.
2 weeks' time to complete his instructions in the matter. Mr. T.C. Sutia appears for the respondents. Let this matter be listed again on
For 2 weeks.
28th
28.
of January.
Kind of complete.
Yes.
That is your lordship. I'm sorry, my lord. That time the brief was exchanged, my lord. My lord, query was 14/12/21. I have gone through the record, my lord. The letter was not for the reinstatement, my lord. It was for new appointment. My lord, my prayer is for
You are seeking restoration.
my lord, 631
By which order was it dismissed?
19/9/2024, my lord.
19-9, please come to 19-9.
My lord. It is deduction.
That is.
All right. Ultimately dismissed for non-prosecution.
My lord. Because I
Yes.
was not present, therefore, respondent authority submits the letter, my lord. It was a new appointment, my lord.
Have you filed your application for restoration?
My lord.
Huh? Asif. All right, heard. This is interlocutory application 4001. Counsel for parties, this IA has been filed, seeking condonation of a delay of 83 days, which had occurred. While filing the application seeking restoration of the writ petition, which came to be dismissed by order dated 19/9/2024. Writ petition being WPC number 36313 of 21 came to be dismissed on 19/9/2024. Well, counsel for the petitioner submits that the delay which had occurred was not intentional. The petitioner was unaware that the matter had been called up and had been dismissed. The counsel who was representing the petitioner was addressing the court in another, it was addressing another court, and in spite of best efforts could not request any other counsel to appear before the court, in which WPC 6313 of 21 was listed. As a consequence, the matter was called up and came to be subsequently dismissed for non-prosecution. Well, the counsel for the opposite party does not object to the prayer made. Considering the submissions made and upon careful perusal of the grounds urged. Negative. The council was not before another court. He was indisposed and was unable to come to the court. And thereby the matter came to be dismissed. Considering the submissions made and the ground urged, this court is of the view that the ground petitioner has been able to explain the delay which had occurred in filing the restoration petition. This delay on the grounds urged is not intentional, and therefore the I stands allowed. The delay of 83 days is hereby condoned. I accordingly stands disposed of.
Deeply obliged.
In this case number 55. This is for restoration.
My lord.
Now the court has already opined that you have already, there is nothing survives in the matter.
My lord, that day I was not present and respondent authority has submitted a letter which was not for the reinstatement, my lord. It was for new appointment. My prayer is for reinstatement from the date of my suspension, my lord.
Learned counsel for the petitioner submits that this court, by order dated 19/9/24, passed in WPC so-and-so, although ultimately dismissed the matter for non-prosecution, it had also observed that in view of the letter 14/12/2021, which was placed before the court, the petitioner was reinstated to the post of driver. And therefore nothing appears to have survived in the writ petition. However, the matter was subsequently dismissed for non-prosecution. Counsel for the petitioner submits. Where is that letter?
My lord, letter 39, page number 39 in court record, my lord.
The IA?
My lord, no.
Huh?
Page number 39.
39.
X, my lord. Yes.
Submits that the said letter. $39.
39, my lord.
There is no 39.
39, 30, it is. X, Marcus,
What is the date of the letter?
my lord, 14/12/2021. Letter.
The communication dated 14/12/2021.
Which was for new appointment, my lord. If I join, then I will lose all my consequential benefit, my lord.
The 14th December 2021 letter, where the petitioner's name is at serial number
18, my lord.
18, pertains to fresh appointment on contractual basis, fresh engagement as drivers on contractual basis. Stop. The claim of the petitioner, it is submitted that the claim of the petitioner is for reinstatement in service
From the date of suspension.
from the date and for setting aside of the termination order. So it is therefore submitted that since by the order dated 14th of December 2021 issued by the ASTC, the same pertains to engagement on contractual basis. It does not amount to reinstatement of the petitioner, and therefore his claim in the writ petition still survives. Under such circumstances, it is submitted that the writ petition be revived and restored to time so that the petitioner is able to, so as to give the petitioner an opportunity of being heard. Thereafter. The prayer made is not objected to by the standing council. Any objections? For restoration accordingly. Upon consideration of the submissions made and upon perusal of the order dated 14 December 2021, the writ petition, the IA number Miss Case 55 stands allowed, restoring WPC 6313 of 2021-5. Where Miss Case accordingly stands disposed of. WPC 6313 be listed for admission on 22nd January.
Item 35.
It's my learned friend to satisfy the court, my lord, last occasion.
Yes.
My lord, first of all, my lord, I'm relying on the judgment, my lord. SBI General Insurance versus Krishna Spinning, my lord, I'm giving on.
Yes, as we have it.
My lord, the last conclusion, my. My lord, the conclusion, my lord, I am reading, my lord. Para 138, my lord. The existence of the arbitration agreement as contained in clause 13 of the insurance policy is not disputed by the appellant. The dispute raised by the claimant being one of quantum and not of liability, prima facie falls within the scope of arbitration agreement. The dispute regarding accord and satisfaction as raised by the appellant does not pertain to existence of arbitration agreement. My lord, I'll pause here, my lord. My lord, by this, my lord, it means, my lord, if this dispute is regarding existence of arbitration agreement, this honorable court can decide. My lord, here in this case, my lord, it is not regarding existence of an arbitration agreement. So, my lord, now I will show, my lord, from our, my lord, contract agreement, my lord, what the contract still exists or not, my lord. Now, my lord, lordship may kindly come to the petition 305. Case 305, my lord. My lord, 55.2, my lord. 305. The provision of clause 63 and 64 of the general condition of contract will be applicable only for settlement of claim or dispute between the parties for value less than or equal to 20% of the value of the contract, and when the claim or dispute are of value more than 20% of the value of the contract, the provision of clause 63 and 64 and other relevant clause of the general condition of contract will not applicable, and arbitration will not be a remedy for settlement of such dispute. So, my lord, once it is crossed 20%, my lord, arbitration will not be a remedy.
Where is that clause for arbitration?
My lord, the previous page, my lord, 63. 223.
My lord, 302, my lord. Yes, ma'am. 63 and 64.
302.
302, my lord. Paragraph settlement of dispute, my lord, down below. Married, my lord. Arbitration and settlement of dispute shall be governed by clause 63 and 64 of General Condition of Contract NF 1998 edition, which are reproduced below, subject to any correction made prior to the opening of this tender. Clause 63, matter finally determined by railway, all dispute and differences of any kind whatsoever arising out of or in connection with the contract, where during the progress of the work or after completion, and whether before or after the determination of the contract shall be referred by the contractor to GM, and GM shall within 120 days after receipt of the contractor's representation make and notify decision all matters referred by the contractor in writing, provided that the matters for which provision has been made in clause number so and so, so and so, and so and so of General Condition of Contract or in any clause of the special condition of contract shall be deemed to be accepted matter not arbitrable. Any and decision of the railway authority there shall be final and binding on the contractor, provided further that accepted matters shall stand specifically excluded from the purview of the arbitration clause. Clause 64. 1, Roman 1. In the event of any dispute difference between the parties hereto, as to the construction or operation of this contract or respective right and liabilities of the parties or any matter in question, dispute or difference on any account, or as to the withholding of railway of any certificate to which the contractor may claim to be entitled to, or if railway fails to make a decision within 120 days, then and in any such cases, but except in any of the accepted matters referred in clause 63 of this condition, the contractor after 120 days, but within 180 days of the presenting his final claim on disputed matters shall demand in writing that the dispute or difference be referred to arbitration. Next clause is 64(1) Roman 2. The demand for arbitration shall specify the matter which are in question or subject of dispute or difference, as also the amount of claim item wise. Only such disputes or difference in respect of which the demand has been made, together with counterclaim or set of given by the railway, shall be referred to arbitration, and other matters shall not be included in the reference. The arbitration proceedings shall be assured to have commenced from the day a written and valid demand for arbitration is received by the railway. The claimant shall submit his claim stating the facts supporting the claims along with all relevant documents and relief or remedy sought against each claim within a period of 30 days from the date of appointment of arbitral tribunal. The railway shall submit the defense statement and counterclaim, if any, within a period of 60 days of the receipt of copy of the claim from tribunal. Thereafter, unless otherwise extension has been granted by the tribunal, place of arbitration. The place of arbitration would be within the geographical limit of division of the railway, where the cause of action arose, or the headquarter of the concerned railway, or any other places with the written consent of the both parties. Now, no new claim shall be added during the proceeding by either party. However, a party may amend or supplement the original claim or defense thereof during the course of arbitration proceeding, subject to acceptance by tribunal having due regard to the delay in making it. Clause 64(1) Roman 4. If the contractors thus do not prefer their specific and
now come to one thing. Your clause under 55(1), which includes 63, there is a specification that claims which do not exceed 10 lakhs, it will be referred to sole arbitrator. Beyond 10 lakhs, up to 3 arbitrators or 2 arbitrators. This appears to be in conflict with this 55.3 or 55.2. It appears to be in conflict, because your your 55.2 says arbitration is only up to 20% of the contract value,
My lord,
right?
my lord,
But 55.1,
my lord,
under which the explanation is provided,
my lord.
it says only up to 10 lakhs, it shall be referred to arbitral tribunal of a sole arbitrator. and
Beyond 10 lakhs,
that-
my lord, it will go to 3 arbitrators, what I have understood. my lord. That's
3
what-
arbitrators.
my-
But there is no capping that it has to be below 20%.
my lord, it is, my lord, the differentiation is that up to, there is two kind of arbitration. One is by one sole arbitrator and one by 3 arbitrator. If it cross 10 lakhs, my lord, then it is my lord. My lord, 20% maybe, my lord, it may be 20 crores. There is no cap, my lord. If my lord 1,000, my lord, if say 1,000 crore contract, my lord, the 20% will be 200 crores.
Now,
And my lord, if it is
55.2 says what?
and my lord, if the contract value 55.2, my lord. My lord, 55 on the provision of clause 63, 64 of the general condition of will be applicable only for settlement of claim or dispute between the parties for value less than or equal to 20% of the value of the contract. And when claim,
What happens if it is more than 20%?
my lord, they will have to go to for civil suit, my lord.
Civil suit.
My lord.
Now, where is the bar that it can't be divided? Up to 20% go to arbitration.
My lord. Now come to my lord, 55.3, my lord.
B.
My lord. But the contractor shall not entitled for ask for reference arbitration before completion of the work. The contractor shall seek reference to arbitration to settle the dispute only once within the ambit of 555.2.
What is the meaning of that?
My lord, within the ambit of that means, my lord, he has to prefer arbitration, my lord, within the ambit of 55.2. That is, my lord, 20%.
That's right.
That 20%.
So where is the bar? Where is the cap?
My
Where
lord.
is the restriction under your rules to say that this 20% cannot be segregated for arbitration, and beyond that they will go for civil suit?
My lord, but here it is not said, my lord, that
It's not said. That's what we are asking you. It's not said that
No.
your entire claim
my lord,
must fall within 20%.
my lord, once, my lord, only once, my lord.
Yes.
Only once settle dispute, only once within the ambit of condition 55.2.
Only once.
Only once.
Only once what?
What, my lord, within the ambit of 55.2.
55.
But that is 20%, my lord.
20%
Yes, ma'am.
says will be applicable for settlement of disputes for value less than or equal to 20% of the value of the contract.
My lord.
When the claim and
When, my lord, it is value of the contract specifically says that value of the contract must be the
we
my lord.
understand that, but I want to know is that what if they segregate it?
My lord, then this whole my lord, condition will become my lord, redundant, my lord.
Why?
My lord, the main my lord,
Why? What is the necessity of incorporating the arbitration clause if you want disputes to be resolved by way of civil courts? Why incorporate arbitration?
why, my lord, I will not go to question why, my lord. Once it is given here, my lord, I will produce two judgments, my lord, whereby the Honorable Supreme Court says that when my lord, the terms of the contract is clear, my lord.
No, terms of the contract is clear to say that up to 20%.
Yes, my lord.
Right?
My lord.
So if there is a dispute of 100%,
My lord.
up to 20%, they can refer it to arbitration.
My lord, pardon, my lord.
If the dispute
my lord,
is up to, let us say, 100%,
my lord,
or 50%, let us say,
my lord,
then up to 20% it goes to arbitration.
Yes.
Rest 30% he will do whatever means he finds like.
Yes, my lord. My lord, they have already crossed. My lord, I kindly see. Lordship has already referred those arbitration to arbitrator, my lord. Kindly see, my lord.
Where?
My lord, 281. Page 281, my lord. 4, my lord. They have segregated my lord, the claims, my lord, into 5, 6 claims, my lord, only to, my lord, this overcome this clause, my lord. 281, dispute 1, 35.25 crores. Dispute 3, 224.65 crores. My lord, dispute 4, 163.330 crores. Dispute 4, 219 crores. Dispute Dispute 5, 219 crores. Dispute 6, 72 crores and 50 crores. These two, my lord.
Your clause does not specify
My
that
lord.
all the claims taken together must be up to 20%.
But my lord,
Must be below 20%.
my lord,
That interpretation we are not called upon to give. Whether that interpretation is there from 55 to
yes, my lord.
you are resisting arbitration because according to you, all the claims taken together will be more than 20%,
My lord,
isn't it?
my lord.
Now show us from any of your
No.
clauses.
My lord, the word once, they can come only once
No,
within
no.
the ambit of 55.
I don't think.
Only once, my
Only
lord.
once
My lord.
is that you come within the ambit once you satisfy 20%.
My lord.
Now they have segregated their
No, they
disputes.
cannot come again and again. Only once, my lord. That is why this word, only once.
I'm sorry, but we can't accept that interpretation. It's not at all. It will be an absurd interpretation. That only once is to include you within the limit of 20%. You are entitled to go for only once you come within the limit of 20%. It doesn't mean that you can come for arbitration only once. How can you give that interpretation?
But my lord, 55.2, my lord, it
55.2 says, but it doesn't say that 20% of the total of all the claims.
my lord, but my lord, it means so, my lord.
No.
Well, I'll read once again, my lord. The provision of clause 64 and 60, the general condition of contract will be applicable only for settlement of claims. Claims, my lord. The word claims.
Yes. Claims.
So whatever the number of claims, my lord, whatever the number of claims, my
Well,
lord.
then the question which is troubling us, you have the arbitration clause in the first
My
place.
lord, I do not know, my lord. I
have
do not
to-
know, my lord.
you have to-
I am go by the, my
you
lord.
have to give us-
I'm strictly go by the, my lord, clause of the contract. And my lord, once they accepted the clause of contract, my lord, they cannot now, my lord, deny.
Clause of the contract will have to be interpreted in terms of the provisions of the Constitution, and that's what the Constitution bench of the Supreme Court says. If it is contra Article 14, we can interfere.
My lord,
Now you have to
my lord,
satisfy.
my
You
lord,
have to satisfy.
my lord.
You are getting into a contract.
Hmm.
You have developed a contract,
My lord.
terms.
My lord.
You have mentioned about arbitration.
My lord.
When you have no intention to go for arbitration. Why?
My lord, look, my lord, kindly see, my
The
lord.
purpose of arbitration,
My lord.
is to resolve the disputes
My lord.
by a mechanism
My lord.
which is outside the regular court system.
My lord.
Now you are saying that we will resort to that only if it is within 20%. Beyond 20%, we are happy to go to civil court. Is it not an absurd interpretation?
My lord, thing is this, my lord. Why, my lord? My lord, in arbitration, number one, my lord, the arbitration in arbitration case, unlike in civil cases, my lord, the huge involvement of my lord, financial involvement is, my lord, required, my lord. My lord, financial involvement, my lord, in arbitration proceeding, my lord, that is not the case in civil cases. My
No, no, don't put it.
my lord.
How can you say that arbitration, there'll be huge or greater financial involvement than in civil court? Civil matters will run for ages. Mr. Roy will be very happy.
Yes, my lord. But my lord, but my lord,
He may even consider
my lord,
reducing
but
his
ultimately
total
this
brief.
is the public money, my lord. We have, if we go, my lord,
What we are trying to understand
My
from
lord.
you, that you are resorting to arbitration,
my lord.
and you are saying that if it crosses 20%, you are not interested because it will have more financial implication. On what materials are you making?
My lord, kindly see. My lord, kindly come to page 281, my lord. Kindly come to page 281.
81.
281. Dispute 2, dispute 3, dispute 4, and dispute 5 comes around, my lord, 642 crores. Now, my lord, if we add dispute 6, it is, my lord, 72 crores and 50 crores. My lord, around 100 crores more, my lord. Now, my lord, it will come around, my lord, more than around 800 crores. And now, Lordship will find, my lord, Lordship will find, Lordship may kindly come to page number 278. 278, my lord. Page number 278, my lord. 278.
Yes.
My lord, second subpara. The value of the contract, my lord. Second subpara, fourth line from the bottom, my lord. Second subpara, fourth line from the bottom. Fourth line bottom, it is, previously it was 987 crore, it is 1400 crores, my lord. And now, my lord, they have,
What is the value? What is 20% of 1400 crores?
my lord, 1000 crore, my lord, in 1000 crore, 1000 crore is 200 crores. And my lord, again, 280 crores, my lord. 280 crores, that is the, my lord, the logic behind it, my lord. They can go on, my lord, claiming some absurd amount, my lord, and will go on paying, my lord, my lord, the arbitrators fees and other things, my
The
lord.
problem is that it is because of your own contract, your own interpretation which you seek to give,
My lord,
that you can only come for 20%, nothing beyond.
my lord.
The contra interpretation would have been acceptable, that up to 20% no arbitration, beyond that, go for arbitration.
My lord.
You're getting a reverse.
But my lord, but thing is this, my lord, I have shown, my lord, one judgment by the one and the other bench of this honorable court. My lord, where, my lord, this 20%, my lord, the 20%, my lord.
Yes, we agree. 20%.
My lord, that
20% of
bench, my lord, but that lordship, under this condition, my lord, this new judgment, my lord, probably this honorable court cannot go into that matter. But
which new judgment?
my lord, this SBI, my lord. SBI judgment, my lord, all dispute has to be referred to arbitrator. Now, my lord, I am questioning the existence of judgment, which can, your lordship can very well, my lord, see whether there is an existence of a contract agreement. I am saying that once it crossed 20%, there is no arbitration agreement. This is my submission, my lord. Lordship may not agree, but my specific submission is that once they cross the bar of 20%, my lord, of the value of the contract, there is no arbitration agreement. That is the, my lord.
That interpretation you have to give by explaining that 20% of all the claims.
All the claims, my lord. Because 55.3 says you can come only once. And my lord, the claims, my lord, it says specifically the claims.
It is an absurd interpretation. That the word once is to be used only to understand that you can only come once. What is the judgment of the court?
My lord, kindly see, my lord, one more, last point, my lord. Page 303, my lord. Page 303, my lord.
Yes.
My lord, the interpretation of 10 lakhs, my lord, here it is given, my lord. Interpretation of, my lord, last clause, my lord, 64.3a Roman 1, my lord. In case where the total value of all claims in question added together does not exceed 10 lakhs, only the arbitrator shall consist of sole arbitrator. All claims, my lord.
What is the judgment of the coordinate bench?
My lord, your lordship.
My lord, the coordinate judgment.
Page 266.
Two six six.
Oh, there is one more judgment, my lord, of your lordship. This is in regard to same contract, same clause, same conditions.
What has happened to these?
The arbitration is going on,
My lord, in
They have
four
not
cases, my lord,
challenged
in
subsequently?
my lord, dispute 2, 3, 4, my lord, finished. 5 is going on, my lord.
But you did not appeal against this.
My lord, only, my lord, come to, my lord, lordship can come to section 16, my lord. My lord, once, my lord, it is referred to, my lord, arbitrator, my lord, and arbitrator, the learned arbitrator decides that they have jurisdiction, my lord, then we can, my lord, challenge it in 34, my lord, after the passing of the order.
That is all right, but this was an order. We are not going to give you legal advice, but
My lord, yes, I'm obliged, my lord. Lordship is giving me legal advice, my lord. I'm happy, my lord.
this order has been accepted. You are proceeding on. It's the same.
They have appointed arbitrator.
My lord, I'll
take
place,
a-
my lord,
Can we take a different view in an absolutely identical manner where a coordinate bench has already?
my lord, then, my lord, I would like to place, my lord, the judgment given in for, my lord, negative equality, my lord. If, my lord, lordship finds that this judgment judgment, there is some mistake in judgment, my lord. My lord, and we could not, my lord, produce the, at that point, relevant point of time. Now the arbitration is going on, my lord.
Whatever it may be, but you are proceeding in arbitration here. Can we take a different view?
My lord,
Unless.
my lord,
we
this
are
point, my
compelled
lord,
to-
existence of, my lord, contract agreement beyond 20%, that, my lord, point has not been raised, my lord.
No, it is there, clause 51.
Yes.
55.1.
That has been raised.
54,
That has been taken, my lord.
63, 64, 55.1.
Now, my lord,
Kindly come to para 4.
my lord, page number, my lord.
Page 268.
Para 4.
26.
Para 4, my lord.
This is a specific objection you have taken.
My lord. Para 4.
Para 4, 268 is a specific objection you have taken.
And my learned friend, Mr. Gupta was there, my lord.
It was not an arbitrable dispute. It is not an arbitrable dispute. My lord,
Because
here I am.
it exceeded 20%. Why didn't you read the complete sentence?
My lord, involved, it was not an arbitrable dispute as the amount exceeded 20% of the contract.
This is your argument.
Yes. My lord, this argument is different from my lord, the present argument. Why, my lord? If arbitrable or not arbitrable, it has to be decided by the arbitrator. Lordship can only see, my lord, whether there is an existence of an arbitration agreement, my lord. I am, my lord, here saying that once they cross the 20% bar, my lord, there is no arbitration agreement. My lord. That is my specific submission, my lord.
That has been taken into account by this
My lord,
judgment. The agreement, the exceeding of 20% will not will result in non-existence of an arbitration agreement is again absurd, because there is an arbitration agreement.
no, arbitration, yes, I agree, my lord. That is why my lord, we have not gone for any appeal. Yes, my lord, sorry.
You may argue that this is an agreement, this is what they have agreed to. The interpretation has to be that beyond 20%, no arbitration. And their claims are 20%. You can't say that beyond 20% there is no arbitration agreement.
Yes, my lord. It's precisely says like that, my lord. Precisely say that, my lord. Arbitration is not, no, my lord. The line, my lord, I would like to once again read, my lord.
No, we are.
Relevant.
Don't take us into
arbitration will not be remedy for settlement of surplus dispute.
Don't argue a matter without taking into account the earlier judgments, precedents being passed. You have to answer what steps have you taken in respect of these judgments and the earlier judgments in so far as railway is concerned.
That is probably
you cannot argue a matter to say that we give a go by to all the other matters. Here we are taking a specific
But my lord, then my lord, I can prove, my lord, this judgment, my lord. This is the, my lord. This is also not challenged by anybody, my lord. This is, my lord. My lord, kindly see, my lord. This is the last para, my lord. My lord, kindly see, my lord.
Where?
My lord, I have given one judgment already there, my lord. On the last occasion, my lord, I have given this copy, my lord. Kindly see, my lord.
This is Beaver. What is the name?
My lord, name is
Enam. Beaver. Give it to me.
In present case, there is no dispute with the fact that petitioner had made claim.
Which paragraph?
My lord, 23, my lord. Para 23. In the present case, there is no dispute with the fact that petitioner had made claim that beyond the initial contract value and such on a prima facie scrutiny of the fact, the court finds that the petitioner has not been able to cross the minimum threshold that is required to decide the dispute between the party by way of arbitration in terms of clause 10.1. To appoint an arbitrator, even though there is no doubt in view of this court that the present dispute is not arbitrable, would lead to a stage of resource besides being sheer waste of time in view of 10.1 of the contract agreement, having barred the resolution of the dispute between the parties through arbitration. The present petition is dismissed. Now, my lord.
Yes.
My lord, I would
What
like
is
to.
the status here? No appeal.
No, my lord. My lord, I would like to, my lord, rely upon two more judgments, my lord, of the Honorable Supreme Court, my lord, if your lordship kindly permits me.
Yes.
My lord, this is, my lord, 2018 6 SCC 534.
Then you have to give us a list of judgments before you start arguing. Because we also study.
Yes, my lord, I'm sorry, my lord, my fault, my lord.
Now,
I have given,
ultimately what happens is whatever judgments you refer to,
my lord,
again, the matter goes to a different date. Have you supplied a copy to the petitioner of all these judgments?
my lord,
Then
yes, my lord.
This is the courtesy, this is followed in
My lord,
practice.
I'll give, my lord, once I read, my lord, I'll give to my lord, my lord, the senior advocate, my lord. I'll pass on this as well, my lord. One I have already passed, but I'm waiting, yes,
No, we are not completing the hearing today,
my lord.
Mr. Roy.
My lord.
There is a judgment of this court giving a contra view. Have you seen it?
This is, I think, my lord, with regard to single contract, my lord.
Fever infra.
Single contract, my lord.
Single claim.
Single claim.
Single or double, we don't know, but has the same conditions.
But they have exceeded 20%. So accept that.
But single contract, single claim, my lord, they have exceeded 20%, it seems, my lord. Anyway, my lord, there are other judgments also from different courts, my lord, Supreme Court, my lord, which there's a latest judgment of 8 August 2025, which says that, my lord, I will read. Lordship may come to para 22 onwards, my lord.
Which judgment?
This judgment, my lord, 2025 SAC online, Supreme Court 1604. This is Managing Director, Bihar State Food and Civil Supply Corporation versus Sanjay Kumar.
Para?
Para 22 come, 22, my lord. I'm not. Para 23, my lord. May I read, my lord? Section 11 of the Act has perhaps been the only provision which would have been interpreted and reinterpreted by the Supreme Court for the longest time ever. After 2 decades of its interpretation commencing from 1996, Parliament intervened and supplied subsection 6A to section 11 of the Act as per which the consideration by a referral court shall be confined to the examination of the existence of an arbitration agreement. Even after introduction of subsection 6A, it took almost a decade for us to have clarity and certainty till the 7 judges bench decision of this court in case of interplay between arbitration agreements under Arbitration and Conciliation Act 1996 and Stamp Act 1899 in re was delivered. In the 7 bench judgment decision, this court considered in the detail the separability of the arbitration agreement from the contract, the empowerment of the arbitral tribunal to examine its own competence, and finally the limits of referral court scrutiny, the relevant portion, which are as follows. But I'm skipping this, my lord. The scope of section 11 is 6A been there, my lord. Now, para 26, your lordship will see, the above reference decision is followed in subsequent decision of this court in SBI General Insurance Company Limited versus Krish Spinning, Aslam Ismail Khan Deshmukh versus ASAP Funds Foods Private Limited and Office of Alternative Architecture, so and so. Now, this is important, my lords. The curtains have fallen. Courts exercising jurisdiction under section 11(6) of the section 8 must follow the mandate of subsection 6A as interpreted and mandated by the decisions of this court, and their scrutiny must be confined to the examination of existence of the arbitration agreement. We have examined the matter in detail. There is an arbitration agreement. The matter must end here. While we agree with Mr. Ranjit Kumar's submissions that this client, that his clients has much to say, let all that be said before the arbitral tribunal. It is, as we have said elsewhere, just as necessary
to follow the precedent as it to be make one. All these issues raised by Mr. Ranjit Kumar, Senior Counsel, are kept open for being raised and contested before the arbitral tribunal. The issues that we have not taken up and left it to the arbitral tribunal are jurisdictional issue involving barring of the arbitral proceedings due to limitation or for the reasons that they are non-arbitrable. These issues shall be taken up as a preliminary issue, and the arbitral tribunal will consider them after giving opportunity to all the parties. So all the judgments have been considered, madam, 7-bench judgment. And there's one more judgment, my lord. My lord, I'm reading para 3, my lord.
Yes.
In a nutshell, the case of the appellant inter alia is that while exercising power under Section 11 of 1996 Act, the court has to
You are
only
reading
examine para 3, my lord.
Three.
In a nutshell, the case of the appellant inter alia is that while exercising power under Section 11 of 1996 Act, the court has to only examine whether arbitration agreement exists or not. If it exists, an arbitrator to be appointed who thereafter would decide whether the claims fall within the accepted category or not. It is thus prayed that impugned order, to the extent it excludes certain claims, to be set aside by leaving it open to the parties to raise all pleas before the arbitral tribunal. Per contra, the learned counsel for the respondent submitted that the High Court is empowered to exclude non-arbitrable claims in light of decision of this court in Imar India Limited versus Tarun Agarwal Projects LLP and other. We have considered the rival submission and have perused the materials on record. The short question that falls for our consideration is whether, while exercising power under Section 11 of 1996 Act, the court has to confine its consideration as to the existence of an arbitration agreement between the parties. If so, whether it would be permissible, while exercising jurisdiction under Section 11, to hold that some of the claims raised are non-arbitrable or fall within accepted category. Subsection 6A of Section 11, which was inserted by Act of 3 of 2016 with effect from 23/10/2015, makes it clear that while considering an application under subsection 4 or subsection 5 or subsection 6, the Supreme Court or the High Court, as the case may be, shall, notwithstanding any judgment, decree, order of any court, confine to examination of the existence of an arbitration agreement. Then 9 about section 6A, the 10, my lord. The significance of the use of expression, not other issues, in the statement on object of reason of the 2015 amendment was noticed by a 7-judge bench of this court in re-interplay between so and so. Then para 11 relying on the 2 judges, my lord. And last final, my lord, para 12. As the above decision has been rendered by a 3-judge bench of this court, after considering the 7-judge bench decision in this court in re-interplay, we are of the view that the respondent cannot profit from certain observation made by a 2-bench judge of this court in Imar Supra. In our view, therefore, the High Court fell in error in bisecting the claim of the appellant in 2 parts, one arbitrable and other not arbitrable, when it found arbitration agreement to be there for settlement of disputes between the parties. The correct course for the High Court was to leave it open to the party to raise issue non-arbitrability of certain claims before the arbitral tribunal, which if raised could be considered and decided by it.
Yes.
So they cannot dissect, my lord, the claim also, my lord. And they have the other judgment of lordship speaking about we have, because we are not a party, so we could not, but we have not challenged it, my lord. But however, my lord, on examining the judgment, it appears that it's a single contract, my lord. And your lordship also see one more judgment, my lord, of your lordship's judgment, my lord, delivered on 16/7/2025.
We'll continue day after tomorrow.
My lord.
You exchange the judgments which are there.
Yes, I'll make a list and I'll give it to you. Lord.
Give it to the court master
Yes,
today
yes.
itself.
Tomorrow we'll give it.
And you exchange the judgments.
Yes.
So I think this is the correct law.
My lord, I'll rely upon two more judgments, my lord.
It is for the arbitrator to decide.
Yes.
What disputes are arbitrable, what are not.
My lord, this is a.
The only point which appears to be in your.
My lord, this is my lord.
Could be disadvantage to the petitioner is that in the event the arbitrator, they are aggrieved by the decision of the arbitrator. They will probably have to wait until the arbitration is over, challenge those questions, number 34.
My lord, moreover, my lord, I'm relying on a judgment, my lord, where it is talking about, my lord, restricted or conditional arbitration, my lord. If it is restricted or conditional, my lord, then